All right. Assalamualaikum warahmatullahi wabarakatuh, and good morning to everyone. Thank you for joining us in our first ever Lex Moot. So my name is Aiman Farique binti Muhammad Zarkashi, and I will become your MC for today. So before we begin, I think I'll just brief you about today's agenda. So at 9:30 a.m., we will have the first slot, which is Introduction to Mooting by Brother Aiman Farique, and then followed by the second slot, which is Differences between Arbitration and Court Setting Mooting. And then we have a short break about around 10 minutes, and then slot 3, which is client consultations, and followed by IHL Roleplay. So, to have our event blast for today, I would like to call upon Brother Saiful Hadi bin Bahrain to lead the recitation of Doa. Please welcome.
Assalamualaikum warahmatullahi wabarakatuh. Al-Fatihah. Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin. Wassalatu wassalamu ala ashrafil anbiya wal mursalin wa ala alihi wa sahbihi ajma'in. اللهم صل على سيدنا محمد الفاتح لما أغلق والخاتم لما سبق الناصر الحق بالحق والهادي إلى صراطك المستقيم وعلى آله حق قدره ومقداره العظيم. Ya Allah, Ya Fa'alun lima yurid, we express our gratitude to you for allowing us to attend the program of Lex Moot 2021. Ya Allah, we ask you for the safety of our religion and the welfare of our body. Allah, Lord of the implementing authority, make the days that we have gone through starting with your mercy, continue with your blessing, and end it with thy forgiveness. And also make the days that we have gone through with guidance and with the victory of excellence. Ya Allah, Ya Muhammad.
Amin Ya Rabbal Alamin. Thank you, Brother Saiful Hadi bin Bahrain, for the Dua recitation. So, before we begin with the main agenda, I just want to inform you that today's event is also our very first collaboration with IIUM Moots and Client Consultation Club. So without further ado, I would like to give the honor to the president of IIUM Moots and Client Consultation Club, Brother Fayez Adesta, to maybe share a little bit of the club itself. Please welcome.
All right. Am I live right now? Am I audible? All right. I'll just make it short. First and foremost, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Fayez Adesta, and I am the president of IIUM Moots and Client Consultation Club. So, IIUM Moots and Client Consultation Club was established last year. Before this, we were under IIUM Law Student Society or IIUM Law SOC, and then due to some reasons, we managed to be an independent club under the university. So what is our niche is that we focus on preparing and also encouraging students to join Mooting, IHL Roleplay, as well as client consultation. These are the competitions that you will have the opportunity to join it later in your degree, And inshallah, I will really be happy to see the current CFS students to join the club as well as the competitions once you are in degree later on. Why is joining these competitions important for your degree life later on? Because first and foremost, joining Mooting, IHL Roleplay, and client consultation will give you a very good platform to improve improve yourself in terms of teamwork. Apart from teamwork, you will also get a research skills as well as advocacy skills. And inshallah, with the help of the club, this will be given to you, and we will make sure that you will get the equal opportunity towards all the students in ICOL later on. So I think I will not waste your time any further, as we have the distinguished speakers to introduce you to Mooting, client consultation, as well as IHL Roleplay. So basically, please do join the club. Once you enter degree later on, you can directly message me if you are interested in joining the club now, so I can make reservations for the current CFS students, so it will be easier for you to continue later on in degree. Once again, do join the club and enjoy the today's so-called webinar. I think that's it from me. Billahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Thank you.
All right. Thank you, Brother Faiz, for the interesting speech. So I believe that now all of us are looking forward to future activities in the main campus, inshallah. So moving on to our first session, which is Introduction to Mooting, I would like to invite Brother Aiman Farique. So I think the honor is yours.
Thank you very much, Sister Naila. Before I begin, can everybody hear me? Okay, thank you. Assalamu alaikum. My name is Aiman Farique. I'm currently in my fourth year, going into my final semester currently. I've been in Mooting since my first semester at UIA. So hopefully I'll be able to share a little bit of what I know to everybody here today. Let's see. Hopefully everybody can see the slides here. Okay, introduction to Mooting. Now, the first question that you really should be asking yourself before we go on to the details as to what Mooting is the background of Mooting itself. It's essentially a simulation of a real life legal case, complete with everything that you really need to kind of debate on and to kind of really do an actual case in real life. For example, if you go to court, a lot of the processes that you go into an actual moot is the same as well in real life. So you get the background facts, the applicable laws is quite important as well, the legal issues, and arguably the most jarring difference between a lot of competitions is the forum itself. So typically, and as you'll get better acquainted with in the second session later, there are two types of mooting competitions. The first is moot court, and the second is moot arbitration. So the differences, of course, again, will be discussed later, but essentially, these are differences in the forum of how you actually do the moot. So in moot court, obviously, you go to court, and moot arbitration, obviously, you go to arbitration. Hopefully, everybody here knows what arbitration is, but perhaps if you don't know, essentially, arbitration is a alternative dispute resolution to court. In your first year later, when you go to UIA later, hopefully everybody will pass your final exams. You'll get to know something called alternative dispute resolutions. They're essentially as stated on the tin, there are alternative methods on how you want to resolve disputes instead of going to court. So The most popular of these methods, and arguably the most formalized of these methods, is arbitration. A mooting competition, to anybody who joins it, can be split into mainly three stages. There are obviously smaller stages in between, but it's mainly split into these three stages: research, which is the longest; memo writing, which takes place around the same time as research as well, I apologize, as you need to essentially put everything that you researched into written form; and oral rounds. So we'll be discussing each and every one of these in a moment. The difference between moot court and moot arbitration. I'll keep this part brief. As previously stated, there is another session after this. But the first difference is choice of laws. So a choice of law, if obviously you should know what laws are, but the differences between laws applicable to court and laws applicable to arbitration are incredibly varied. This is due to the fact that arbitration is an incredibly free form of dispute resolution. So, in the parties involved, i.e., the claimant and the respondent, are allowed to choose from everything from their procedural laws up to the laws that adjudicate the actual contract involved, for example. Um, Again, these are things that kind of go deep into the laws itself and go deep into discussions. I don't want to turn this into a lecture, but the main difference, I apologize, the main difference between moot arbitration and moot court is in their choice of laws. The second difference is in their level of formality to a certain extent. Um, in the following slides, you'll be seeing a lot more pictures as to the actual competition itself, hopefully in the second session. And you will see quite a bit of difference between the level of formality between these two types of competitions. What do I mean by level of formality? When I say level of formality, it's not as if you should dress slovenly or you should not be wearing a suit when you go to the actual competitions. You still need to do that, but uh, typically speaking, in an moot arbitration, you'll be sitting down. That is a pretty big difference. Well, in moot court, you'll be standing at every moment when you're actually speaking to the court itself. Some other differences between these two competitions would be like how you speak to the judges involved. For example, in a moot arbitration, you can, in some competitions, mention the names of the actual judges involved, while in moot court, typically that is very frowned upon. And instead, you should be speaking typically to their actual titles based on the context of the competition. The next difference is dress code. So again, there's not much of a difference between the two, but if you want to wear a more brightly colored tie in a moot arbitration as compared to moot court, it's possible. Typically, your coaches will not really allow that, but it's allowed. There's no rules against it. Compared to that, in moot court, there are typically very strict rules on how you should be dressing. As with similarly in actual court, the difference being that you don't need to wear your robes, for example. And finally, in setting. So, as previously mentioned, in moot arbitration, you'll be probably be sitting down. You won't have that many people in the room with you unless it's the final competitions. And there'll be typically one or three judges on a odd numbered scale. So the main difference here is, I think, a general air of formality as compared to arbitration in moot court. Moot arbitrations, in a certain word, is less formal. There's no need to be too strict with yourself when it comes to formality in moot arbitration. You can, typically speaking, speak to your judges, who are, of course, obviously either actual arbitrators or very seasoned lawyers. In some certain competitions, you can speak with them on a more personal level as compared to moot court. And I'm not saying this as if to boost up moot arbitration or anything of the sort, but I guess it depends on what you want at the end of the day. I'll be discussing that a bit later, but first things first, let's go into the stages of a moot competition. The first stage, the research stage. It is the longest period of time for any moot. and it typically lasts between 1 to 2 months. Again, it depends on the competition itself, because some competitions that I've personally joined take anywhere from 3 to 4 months in their research stage alone before going into oral trainings and before going into memo writing. But a lot of local competitions take only around a month or two. Team members are separated and assigned to individual issues. So this is really dependent on your team if you join a competition later. But typically speaking, when you're going into an actual competition itself, the first thing that you do as a team is to sit down and read the moot problem. So a moot problem, I'll be showing you an example later, but a moot problem is essentially the background for the entirety of your experience in mooting. You'll be given a certain set of facts with a certain set of laws and a certain setting in order for you to really start debating the issue itself, to really go into the issue itself, to research the laws. So when you're researching, um, as previously stated, you'll be separated by individual issues. So if you've done any form of legal research whatsoever, you will know that in any case, there are multiple issues involved in the case itself. Even though you normally looked into a case for a specific topic, at times you will have multiple issues, most of the time actually, you will have multiple issues in the case. And it's the same for any moot as well. So when you go into the actual moot problem, hopefully at the end of the moot problem itself, it's a pretty hefty document, typically speaking, you will have a set of issues that they have given to you to research based on the facts given above. So a typical sources for research, um, Google, even though a lot of people may not respect Google as much as it actually does help you in legal research, at least, it's actually quite useful for certain competitions, especially where you don't have access to easily found databases. So, for example, in a local competition, it's quite easy. You just go to LexisNexis, which I hope everybody here knows, and just look through and sift through the research and cases involved. LexisNexis right now is quite modern, and it's quite easy to really sift through to find the case that you want for particular cases, for particular issues. PACE. PACE is something that is really only applicable to CISG issues. It is something that relates to private international law, meaning, um, for those who don't know, the difference between public international law and private international law is the difference in the parties involved. Private international law is typically for two private parties, meaning companies, individuals, so on and so forth, on an international scale. So PACE is actually a university, and they give out a free database of cases for CISG issues which relates to trade disputes. Essentially, if you have a contract with two private individuals on an international scale, and normally that contract will be governed by CISG, and quite a few moot competitions go on into that actual set of laws. And finally, scholarly articles. Um, there are, if you go into UIA later, you'll be getting access to the database, the UIA database, and there's quite a few databases within that UIA database that you can look through to find scholarly articles. But typically, Google works just fine. There are ways to really narrow down your research stratosphere to find specific articles that is relevant to your case. Next. So this is an example of a moot problem. It's actually the most recent moot problem for the VIS moot competition, the Willem C. VIS moot competition. The legal issues that I mentioned to you is actually there. If you look at the bottom part of the second page, the one titled Procedural Order number 1 at the top there, if you look at the one right below the paragraph that has 3 Roman numerals, below that they will see A, B, C, and D. So these are the legal issues involved, and they are given to you for most moot competitions. Not all. Some for make you find your own legal issues, but typically for most international moots, for the standard is that you are given the actual issues in the moot problem. Second stage, memo writing. Well, this should be done at the same time or contemporaneously when you do your research. So whenever you find something new, hopefully you've already started with your team. A Google Doc, for example, is quite a useful tool nowadays to really start doing your memorial. It's a pretty difficult task, honestly speaking, especially if you're in your first or second year of university and law school. But it's a fantastic training ground for you for your later experiences as a lawyer. In your third year, you'll be experiencing something called LAP. Essentially, it's an internship program for all law students. You have to go through this. You'll find out just exactly how much paperwork a lawyer has to go through. It's a lot. It's quite a lot. So if you're doing your memo writing and if you do it well, hopefully you'll be training yourself to really do better in paperwork at a later date. And plus, it's something that differentiates itself between a lot of competitions, and it's very free for you as well, as with most paperwork in the law field later. So the format changes depending on the competition. What this means is that depending on the competition that you join, whether it's if it's international, for example, um, the American style of a format regarding the memorandum is completely different compared to the European style and what they want from a memorandum. And the same can be said for a Malaysian or local competition. So again, the best experience, the best way for you to learn all these things is to join an actual competition. But that's for later. The importance of a memo differs depending on the competitions. A lot of moot court competitions really place an emphasis on your memorial, and they actually give you points depending on how good your memorial actually is. In fact, a lot of competitions, the teams have done incredibly well for their oral rounds, meaning when you speak, but for one reason or another, they did not do quite as well in their memorial writing, and that causes them to be quite a bit lower on the competition. So again, mostly for moot court competitions, moot arbitration competitions don't typically have this issue, as they focus mainly on the oral rounds and they give a separate award for memorials and outlines. And the length is similarly variable. I have seen memorials go from anywhere from 5 to 10 pages to 60 to 90 pages. So again, it really depends on the competition that you're joining. This is an example of a memorandum. It's actually my and my team's memorandum from this recent competition. So you should note that obviously, since we are actually representing the university, we'll be putting up our logo there as well. Obviously, the title and the names of the parties involved, and quite a few of the format. There's not much for me to speak here, mainly because the format of your memorandum, if you join a competition later, could be very different from what you see here today. So, in any case, this is essentially what a memorandum should look like from the beginning in certain competitions. And finally, arguably the most exciting part of this discussion all arounds. So that's actually a very small part of your experience in mooting. For the most part, it's research and writing. So again, we'll be discussing that a bit later. But the important part is that all rounds only take place in a typical span of 2 to 3 days. It's not that much time, but it's obviously the most stressful part of your experience in mooting as well. The format differs between competitions. What do I mean by format again? The format between a moot court competition and a moot arbitration competition differs wildly, mainly because the setting in which you do it is also, of course, completely different. I don't want to take too much of this from my speakers later, but essentially, you just need to know that they vary quite widely between competitions. Formality also differs depending on the competitions. As I've previously stated, if you're in a moot arbitration competition, you typically don't need to say Mr. Arbitrator for every single person that you speak to, or Mr. President. If you think that you have a good memory and you're able to remember the names of each and every one of your arbitrators in the competition, then perhaps use their titles and their names. But in a moot court competition, that's typically frowned upon, and that's just one of the many formalities that you need to go through in the actual competition itself. So these are some examples from oral rounds that I have participated in, and some of my seniors have participated in. But unfortunately, I didn't have that many pictures of moot court competitions. Hopefully, Muhannad will have more for you later. But these are moot arbitration competitions, and they're mostly been done at the AIAC, the Center for Arbitration in Malaysia. So you can see there and note that in the bottom picture, there are three arbitrators or judges, and there are four individuals that's speaking, two on the right side and two on the left side. So, of course, these two represent the parties involved in the case itself. And unlike in moot court competitions, it's mostly two people with perhaps a third individual there as bench, meaning that they don't speak, instead just help along with the team. So, for the final part, and before I end my introduction to mooting today, the final question: should you join mooting? It's a loaded question because I won't lie to you. Mooting takes a lot of effort and a lot of your time and a lot of investment in order for you to really get something worthwhile back. But if you do get that far, and if you do put in the effort and the grit, then to be honest with you, it more than gives back in terms of investment. If you are serious about going into law, and if you're serious about being a law student, and if you are planning on practicing law instead of perhaps going into the research field instead, and if you're really keen on actually reading and practicing law as a whole, then you should definitely be joining mooting. Mooting gives you so many advantages. It's not just about training your skills in terms of speaking, in terms of writing, in terms of research, which it does. It helps you with all of these things. But arguably, one of the most important aspects is how you network and how much you can network with mooting. It may not really be important to you right now, going into CFS and going into your first year in UIA, but going into your third year and going to your fourth year, and obviously going to chambering later, it will be incredibly important for you to have those network and those connections with you, for you to get into a good firm or a good place in order for you to practice law later. For example, for this not recent necessarily, but for your internship later in your third year to SEM, if I'm not mistaken, if you are in mooting and if you've hopefully done a few and you've made a few connections and you've known quite a few people, you made a name for yourself, then when you really send your your applications later, hopefully those individuals that you have known from these competitions will of course recognize you and allow you to join. In a lot of cases, they will actually invite you to join them in their firm. Of course, this depends on your year and on your experience during the actual competition, how well you do. But I've seen it multiple times where my seniors have been asked by lawyers and partners at firms for them to join their firm. So at the end of the day, if you are really serious about practicing law, then there is nothing stopping you from joining mooting. And in fact, it is very much encouraged. If there's nothing else, I would like to end my introduction here. Thank you very much.
All right. Thank you, Brother Aiman, for the interesting speech. Actually, now I'm quite eager to join mooting later in Gombak campus. So I believe that, as in right now, we already have better understanding about the basics on mooting itself. So for the next session, we will have Sister Maryam Khalisa and Brother Muhannad Munir to explain further on the differences between arbitration and court setting mooting. So for the first one will be arbitration by Sister Maryam. Please welcome.
Assalamualaikum everyone. Can you all hear me? Okay, thank you. Alright, so my name is Maryam Khalisa. I'm a fourth year first semester student. Next semester will be my last semester here. So today I will be presenting on an introduction to arbitration moot, what it is and how, and the process. So before I start, I would like to share with everyone a video of the biggest arbitration moot competition in the moot world, I guess. So this is a competition which our university won. So let me share for. Everyone can see, right?
Everyone is ICC Young Arbitrators Forum and AIEC Young Practitioners Conference. Training in international arbitration, procedure, substance, and enforcement. CC, YAF, AIAC, YBG Conference. And what we are saying is not only correct, but the most reasonable and the most logical.
We're currently here at the pre-moot in the AIC, and as far as I can see, the teams are preparing for the international commercial moot, and I look forward to see the teams again in Vienna, and it has been an amazing experience. Looking forward to learn much more and gain experience in this event.
So we will have dinners like this, and the arbitrators will be from all around the world, foreign arbitrators. This is the AIC.
I think just the constant competition.
Okay, forward. Okay, this is our team. We made the finals. We made it to finals. Okay.
Had the opportunity to understand or be introduced to ADR for them to see firsthand what a real international arbitration looks like.
Okay, so that's the end of the video. So now I will move on to my actual presentation. Okay, how do I share this? Okay, present. Okay, so now we will see the introduction to arbitration moot. Okay, so generally, before you begin mooting, there will be 4 steps which are firstly the constitution of the team, and then research, written submission, and oral submission. So what is the constitution of the team? When you join Mooting, there will be a selections. So not every so to be a part of a team, you will have to come to the selections, and from there, the moot judges, like is usually our lecturers or senior mooters. They will be the arbitrators. They will judge you and evaluate if you qualify to be a part of the team. So the selections are usually fairly competitive because you're competing with your friends to be in the team. So, but it's actually very fun if you actually make it to the team. However, yeah, okay, so when you become a part of the team, you also have to do the research. So research starts from the moot problem. First, you have to read the moot problem, understand the issues, and then you go work your way from there. So like Aiman said just now, research takes up a lot of time. It is probably the biggest chunk of mooting because you need to know your legal issues very well as your authorities. So it may go up to 6 months even. The shortest would be 3 months. I've ever joined is 3 months to 6 months. And then you also have to write the written submission. The written submission is a written form of your arguments. Sometimes you will be bound by your written submissions in the oral pleadings, but most of the time you are allowed to depart from your written submission given that the tribunal allows you to. Okay, so what is arbitration? Arbitration is a type of alternative dispute resolution. It is an outside of court settlement, so it is an alternative to court litigation. Usually, the subject matters which you can bring to arbitration includes almost every civil dispute, such as commercial disputes, family dispute, construction, investment, trademark infringement, and many more. But usually our competitions focus on commercial and sometimes construction disputes. So what are the advantages of arbitration? First of all, there will be no element of compulsion because parties go to arbitration in their free will, unlike court litigation. And secondly, parties may choose the arbitrator. Unlike in court, you can't choose the judge, the presiding judge, right? But in arbitration, you are allowed to choose who you want to be the judge, who will judge your dispute. So that is a flexibility right there. So sometimes there will be a panel of 3 arbitrators, sometimes just 1. So if you're curious, an arbitrator is someone who acts like a judge. So this person will be the judge to the dispute, but instead of calling it a judge, we call them the arbitrator. So if there are 3 arbitrators, we call them a tribunal. Okay, but if there's just 1, then we just call a sole arbitrator. So the arbitration is not as strict as court litigation because, like Aiman mentioned just now, counsels have the liberty to sit down while submitting. So you will be seated in a manner which Aiman mentioned just now, like in a meeting room. So it's not held in court, it's usually in the arbitration center, and the dispute is 100% confidential. So it is good for business entities and it's more relaxed and speedier. Okay, so this is example of the arbitration center. This is the AIAC. If you've never heard of it, the AIAC is the Asian International Arbitration Center, Kuala Lumpur. So this one is the Bangunan Sulaiman. It's very beautiful inside actually. It is located near KL Central, and the meeting room that you'll be submitting in is the one on the right. So you'll be sitting somewhere like in this position. So the arbitrators will be here, and you'll be sitting here and here. Okay, it's a very beautiful place. And then the list of arbitration moot competitions. So for first-time mooters, we have NAMCO, which is the Novice Arbitration Mooting Competition. It is specifically made for first-time mooters who wishes to begin mooting career. It is very interesting, usually involves breach of contract. For Law Asia, it is an international moot competition actually. So the winners of the national round will get a chance to go to any Asian country depending on the year of that moot, that depending on the country which they choose that particular year. So like our seniors have actually won Law Asia and are forwarded to the international rounds in Japan, where they won first runner-up. And the biggest one would be the William C. Vis arbitration moot. Usually involves commercial disputes, and there will be a preparation for this moot, which is called the pre-moot. So the pre-moot is held all over the world. We have sent teams to Seoul, and we've been involved in many international friendly competition with universities from all around the world. And our seniors have also went to Vienna because they won the Malaysian round. Yeah. Okay, so what is your task in an arbitration moot? So in the moot, you will act as a counsel representing either the claimant or the respondent. You will not act as the arbitrator. You will not judge the dispute, but you will be representing a client. So your task is to convince the tribunal to grant your client's request. So to win, the tribunal will see which side presented their case better. So you have to make sure that your case is very well thought of and very concise and precise manner to win. So next we move on to the format of the moot. So usually in arbitration moot, we will have two issues. Like Aiman mentioned just now, there will be multiple issues, but the breakdown of the issues will be 2 issues for procedure and 2 issues for merits. So for the procedure issues, it usually concerns with rules and standards which the tribunal has to follow in deciding the dispute. So procedure issues, some examples include, does the tribunal has the jurisdiction to hear this case? Did the party consent to be brought to arbitration? Does the party even have the locus standi to appear before the tribunal today? So these are some procedural issues. And usually for procedural issues, you will not talk about the actual breach of contract, but you will talk about the process, the validity of this process which you wish to bring to arbitration. Usually it's much more complex for first-timers, but as you read up on procedural issues, it's actually, it can be very simple. Yeah, okay. And then next is the merits issues, the most juicy part of the moot. It concerns with the matters which actually give rise to the dispute. So some examples of merit issues include breach of contract, or sometimes whether the party did a certain act which constitutes the breach of contract. So how many persons in a team? Usually, it depends on the rules of the competition, but most commonly we will have 2 claimant and 2 respondent. Claimant is the plaintiff, or the respondent is something like the defendant. So it could be 4 in a team, 2 in a team, or 3 in a team. So if it's 3 in a team, there will be an anchor who will be representing both the claimant and the respondent. So this person will have an extra burden, but this person can also get higher marks, but it will be a lot of effort. Okay, and then we will sometimes have the researchers. The task of the researchers is to assist the oralists to find authorities. So some of you might think, why would someone even be the oralist when they are not orally submitting? But it is actually a very useful experience because you will have the opportunity to sharpen your research skills as well as equip yourself with better knowledge of the moot before you join an actual competition. The submissions usually take between 15 to 20 minutes. It depends on the competition of the rules. So usually people ask me, why is it so long? What are you going to say in 20 minutes? But because in debates, it's usually sometimes just 7 minutes or 10 minutes. But trust me, when you get to the oral submissions, you will understand why it's 20 minutes. Sometimes you even need to request for extension because there are just too many things to talk about. And then we have the rebuttals. Similar like debate is 1 or 2 minutes or 5 minutes. It depends on the rules. So the flow of the submission. First of all, we will have the there are no fixed flow of submission, but most commonly in competitions, we will use the one on the left. The procedure claimant will start first, and then the merits for the claimant, and then procedure for respondent, and then merits for respondent. So it doesn't go like this. It doesn't go procedure, merits in the common competition. Okay, so the claimant will explain first and then the respondent. And then for some other competitions like the William C. Moot, the procedure will start first and then the procedure for respondent will counter to the procedure for claimant, and then they will straight move on to the merits of the respondent, and then they will move to the merits of the claimant. So as you can see, it's like an inverted C in the William C. Moot. I guess that's why they name it William C. Moot. Jokes aside, this is the reason why the flow is like this is because usually the party starting first will have an issue to propose, and the party who starts next is the party who has to reply. Okay, and now we move on to the oral submissions. The structure of the oral submission. So I will not be talking about the written submission because Aiman has mentioned the written submission, and also in the written submission, it will also apply the same rules as the oral submission. So the structure of the oral submission, first of all, you will have to introduce yourself. So introduction usually goes, good morning, panel of arbitrators. My name is Maryam, appearing on behalf of the claimant. The respondents are represented by the University of Malaya, probably, but you have to introduce your opponents as well. Because mooting is a very poised and polite way of arguing, to be honest. It is much more polite than debate because you will have to observe the usage of your language. Just like court, you have to also observe some decorum in arbitration. Although you'll be sitting down, you will have to respect the panel of the arbitrators, respect the opponents. So you will have to carry yourself in a very pleasant manner. Okay. And then second, you have to provide a roadmap. A roadmap helps the arbitrator to follow your issues. So for the roadmap, you may say, panel of arbitrators, the claimant has 4 issues to submit. I will be discussing the first 2 issues and my co-counsel will be addressing the remaining. So my 2 issues are firstly, what? Secondly, what? So you will have to always signal the tribunal when you're moving on. Okay, so that's the 4th point, but okay. So the 3rd one is answering the judge's question. This is the most important part of the moot. It carries the biggest marks for your submission. So when you answer the judge's question, you have to make sure it's very concise, straight to the point, not going around the bush. So an example of how you can answer the judge's question is you may thank the tribunal. Thank you for your question, and then you explain why. And if you disagree, you may respectfully disagree with Mr. Arbitrator, but you need to tell why. And then if you move on to your next issue, you must also address to the tribunal that Mr. Arbitrator, I have now finished my first issue. I would like to now move on to my second issue. So this helps the tribunal to not be lost along the way. So number 5 is when you refer to the moot problem. So when you make the oral submission, sometimes you have to refer to the moot problem. So you want to address the tribunal. What page are you at and what paragraph? This helps the tribunal to follow your arguments clearly, because how else can you listen to someone for 20 minutes without getting lost? So you need to refer them constantly. And then number 6, extension of time. So when you exceed your time, you need to ask the tribunal for an extension of time. So if they grant you, you may continue, but if they do not allow, so you have to wrap up your submissions immediately. And then number 7, request for relief. It is the end of your submission. Now you're going to end it. So request for relief is only for the last speaker for each side, last speaker for claimant or last speaker for respondent. So the request for relief is where you tell the tribunal, you respectfully request the tribunal to grant what your client wants. So, and lastly, can you go to the restroom? The answer is it's not advisable. I have been in this situation actually because the process will be very long. It will be 40 minutes long. So but you have to remain focused for rebuttals. That's why you cannot go to the restroom. So it is advisable if you go to the restroom before the rounds. Some important considerations for oral arguments include you must be well organized. During the competition, you cannot have a messy table. You need to have your materials ready in front of you. Preferably just one paper, one like notebook, and your moot problem. Your moot problem needs to be binded and tagged in a way that is easy for you to refer. And then secondly, you need to always use simple language because simplicity is much appreciated in mooting. Think about how you would explain the argument to a friend who has never been in law school, who's never heard of your argument. So try to make it as simple as possible. And third, you need to remain calm. Usually, it is normal for people to feel nervous in moot competitions or public speaking in general, but you need to always be comfortable and speak in a normal pace. Try not to go too fast because it will distract your judges. And the main point of mooting is to convince your judge. That's why you don't want them to be lost. Okay, and also you need to be friendly to the opposing team. This is because you need to bear in mind that the opposing team is not your enemy in court or in the arbitration, because your enemy would be the tribunal. The tribunal will bombard you with a lot of questions, and you cannot be rude to them if you get sick of the questions, but you have to politely address them and know when to stop addressing if they're not necessary. Okay, and conclusively, that ends my presentation. I would say that the arbitration mood is a very enjoyable journey. It's very relaxed and suitable for people who have stage fright when they present in a very strict environment. Like for me, I have only been in arbitration mood and I personally enjoy it. Before I end, I would like to share some pictures and some past experiences of the mooters in IIU, so you all can have like a look of, like an overview of the arbitration mood. Like I mentioned before, the competitions, some of the competitions are international, so not only you get an international certificate, sometimes if it's not coronavirus, you can go to these countries, and the university will sponsor the accommodations and everything. If you win the national rounds, so like the William C is in Vienna and Law Asia in Asian countries and a lot more. So the past moods we have sent. In William C Viss mood, okay. So this, I'm sorry, I got distracted by this, my coach. Okay, William C Viss mood. This is our team who won the 3rd AIAC pre-moot, the Malaysian round. So they managed to advance to the Viss moot. So the Viss moot, you can only join if you win the Malaysian round. So they went to the Vienna University for the Viss moot. And they also went to a pre-moot, which is a preparation for the Viss moot in Seoul, where they actually won this competition. And Mr. Aiman here won Best Oralist. Yeah, so he's my teammate now. Okay, so the moot will have very exciting meals, delicious meals. They will keep you full all the time with delicious meals. You will have fancy dinners, See, here is like a lot of desserts. Well, this my friend did not do justice by taking these kind of photos, but trust me, the food is good. And then Law Asia, we have Law Asia. This is a competition which I participated. We have past teams who went to Japan for Law Asia because they won the Malaysian rounds. During my year, I did not win this competition, but I got third place with my team. But yeah, the winning team did go to Hong Kong for Law Asia last time. And then lastly, we have Namco, the first time mooters. This is a very this is a competition which is very dear to my heart. It is my first ever mooting competition. This is my team. We sent 2 teams. So you know here, this is Mr. Alan Raza, the famous lawyer. This is our team. This is the recent Namco team who won. Who's the champion of Namco 2020. So this is team 2 of the 2020 Namco team. So the dinners will be like in a banquet like this, and then we will also do it in AIAC. So that concludes my presentation. I hope you enjoyed it. I hope that you feel motivated to join Mooting now. Personally, if you ask me whether Mooting affect my studies, I would say no. To the contrary, it actually helps me. And at one point, when I joined Mooting, I was put in a lot of pressure to finish my assignments quickly. It teaches me how to manage my time better. So that is all from me. I hope you benefit from this brief session. Thank you very much. I would like to now move pass this to the floor.
All right. Thank you, Sister Maryam. I think I'm pretty much excited about arbitration, but I'm not going to be biased today. So let's hear from Brother Muhannad Munir first about court setting mooting. Tafadhal mashkura.
Okay. Assalamu alaikum wa rahmatullahi wa barakatuh, and good morning to everyone. Before I begin, can everyone hear me here? Okay, that's good. All right, so I will be sharing my screen. All right. All right, so just as a brief introduction, I'm in my 3rd year, 2nd semester, and next semester I'll be entering my final year. I joined Mooting in my 1st year, 2nd semester. I've been part of 2 different mooting competitions, and today I'll be sharing on what is court session mooting, including the process of how it works, as well as some advice which I wish I had known before I joined my first mooting competition. It's mainly on the oral submissions. So moving straight into this topic, what is court setting mooting? Now, as Aiman stated in his introduction, mooting is a simulated proceeding. But when it comes to court setting mooting, this is a simulated court proceeding. This is very similar to an actual court proceeding where there would be a number of legal issues on a particular subject matter of law. So later we will see a list of different competitions where you will see that there are very different areas of law that would be tested in these competitions. And when it comes to the differences between court setting mooting and arbitration, Maryam has pointed out in her slides in the advantages of arbitration that one of the main differences would be formality. And this is something which you as a mooter, when you enter mooting, you will realize this instantly, because you will realize that when you are in a court setting mooting, formality is very strict there, where you'd have to maintain formality in your submissions and when engaging with the judges. And hopefully later I will share a video with you just to show how it works in a court setting mooting. All right, so this is a picture of me participating in a court setting mooting. This is in ICOL, in fact. So this is how a court setting mooting would look like. Typically, there would be 3 judges, but because this was the grand finals, there were 5 judges. And now I will explain how does this proceeding work. So usually in a court setting mooting, for each party you would have 2 speakers, also known as oralists. Now these oralists will present the legal arguments before the court, just like the picture I showed. And usually there would be a third member, which is known as an off counsel. So if you look at the picture here, on this side, this is the team 1. I am the first speaker. This is the second speaker, my teammate Muaz, and this is the off counsel. So an off counsel usually would have a supporting role. They do not present any oral arguments before the court. What they do is that they help the 2 oralists by listening to the opponent's legal arguments, and also by helping to prepare any rebuttals or to search for any legal authority which the 2 oralists would need. And the procedure when it comes to a simulated court proceeding would be similar to a real court proceeding, where judges would first enter the moot court, and after the clerk would announce the matter before the court, the oralist would be called to present the legal arguments by standing behind the podium, just as in this picture. And as regards to the time duration of how long an oralist would take, that would depend on the competition. Mostly it would range from 10 to 20 minutes. And while each oralist would be presenting their legal arguments, the judges who are sitting on the bench would be asking different questions to the oralists. And after one team finishes their legal arguments, the opposing team will then present their legal arguments. So once both teams have presented the legal arguments, there would be a short round of rebuttals and rebuttals, which we'll get to later. But essentially, rebuttals is where the claiming party or the applicant party would rebut the arguments of the opposing party. And rebuttals is where the opposing party would rebut the rebuttals of the claiming party. So after this is over, then the court session will adjourn and the judges will deliberate on the decision as to which party has won the court proceeding. And when the judges deliver the decision, they will provide some feedback as well. So actually this feedback part is really important so that you can actually take in their advice and incorporate this when you join your next mooting competition. So now we will go into how to excel in a court setting mooting. Now, when it comes to research and written submissions, it's very similar to what Aiman and Maryam has stated. But what makes court setting mooting different from arbitration in some ways would be the oral submissions part. And this is where I would really like to focus on today, because I feel like this is something which would really help students before even entering their first competition in ICOL. So I have divided this part into 5 parts. We'll be covering each part. And the first part would be on the advocate's demeanor. Now, before I even move on to the first tip on the advocate's demeanor, what is an advocate's demeanor? So an advocate's demeanor refers to an advocate's behavior. And this means how an advocate would carry themselves in terms of their facial expressions, their body language, and how they would address the court. So moving on to the first tip of an advocate's demeanor, that would be making eye contact. Now, I'm sure throughout CFS, you'd have a few presentations and in your physical classes, you'll notice that a lot of marks is given in the rubrics for making eye contact. And this will still be the case throughout your entire degree. Now, making eye contact is not just important when it comes to presentations for classes. It is extremely important when it comes to mooting, because it actually can really help differentiate between scoring high marks and scoring low marks. So when I say making eye contact, this is to make eye contact with the panel of judges that is in front of you throughout your entire submission. And the reason why this is really important is because by giving eye contact, you'll keep the judges engaged and interested in your submissions. They would not be bored of your submissions. And on top of that, you will appear confident, even though you may not necessarily look confident, because sometimes the nervousness in the situation would get the best of you, but giving eye contact would definitely help you appear confident. Because I remember in my first mooting competition, one of the judge asked me a question which I was never asked before, and I was really not sure on how to answer it. But I just answered it using whatever I knew, and I made sure I gave firm eye contact. And the judge told me in the end that he knew that I did not really know the answer, but because I appeared confident, he gave me marks for it. So I think it's really important to make eye contact. And another thing about eye contact, from what I realized from watching a few mooting competitions, is that some students only give eye contact to one particular judge only, and that is not really a good thing. So what you want to do is equally give eye contact to each judge in the courtroom. So even if one judge is only asking the questions throughout the entire session, because as I stated earlier, there would be at least 3 judges, you still have to give eye contact equally to all judges, even to judges who don't really ask questions, just so that they don't feel left out. And I feel like this is something which not many students take into consideration of. All right, so moving on to the second tip, that would be to work on your body language. Now, body language is where it sends a really strong message to court that you are firm and confident in your submissions, just like making eye contact, because the whole goal of mooting and submitting your arguments is to appear firm, confident, and to have faith in what you're actually presenting before the court. So to do this, you should practice standing firmly behind the podium with your head held high, and also try not to use too many hand gestures because they can be distracting. Try to use them only when it's necessary to convey the meaning of a particular word or even phrase. And another thing is that body language is not just important when you stand up behind the podium. It's very important as well when you sit down on the council table, because I have noticed in some competitions where even in the council table, the oralists would not actually maintain body language, meaning that they would end up talking to their co-counsel, they would end up moving too much, or they would end up frowning or showing disapproval with the opponent's submission. And that's not something which they should do, because judges in fact take note of that. So remember that body language is not only when you're submitting, but also when you're at the council table. Now, one advice which every senior mooter has given to me and my teammates when it comes to body language is to always record ourselves with our phone camera whenever we are submitting, to identify any habits that may distract the judges. Because some of us may take the pen and play with the pen. Some of us may always touch our hair. So by recording yourself, you will be able to see which habits that you may have to stop slowly. All right. So moving on to the third tip, when it comes to advocates' demeanor, there are certain terms which I believe must be avoided when it comes to mooting. So, and this is something which I think was not taught to me when I joined mooting, and I heard this from my friends and seniors rather than learning it. So the first thing is, of course, do not say I think or I believe whenever you are presenting before the court. Instead, you should say we submit, because by saying what you think or what you believe does not actually matter. It is your submission that matter. Another thing is that do not say yeah or yeah. This is quite informal. As I said, court setting mooting is extremely formal. So a better word to use would be yes. Another thing is that do not use we wanna. Say we would like to instead. Do not say I am sorry, I don't know. Although this may seem quite normal, but a better phrase would be I cannot assist the court in this regard. And lastly, this is quite common actually. Many students like to say when the judge is asking them about a fact or even a law, they would be like, actually, as a matter of fact. So it's better to say according to paragraph, whichever paragraph of the moot problem. So formality is extremely important when it comes to court setting mooting, because although this may seem minor, it can really trigger a few judges. All right, so moving to the fourth tip of an advocate's demeanor, this is addressing the judges. Now, I believe Maryam has explained a bit when it comes to arbitration. So when it comes to court setting mooting, this would depend on the competition. Now, for international law competitions, each judge, because there would be at least 3 judges, each judge can be addressed as Your Excellency. Or collectively, if you would like to address all 3 judges at once, you could address them as Your Excellencies. And usually the judge that sits in the middle is known as a chief judge, and you would want to address the chief judge as either Mr. President or Madam President if you're only addressing the chief judge. And for mooting competitions based on national law, judges can be referred to as Young Arif. When it comes to addressing advocates, each oralist is addressed as agent, and you may refer to your teammates as my co-agent. And if your teammate has a third member, they can be referred to as an off-counsel. So if you would like to address your opponents, you can refer them as my learned friends. And for mooting competitions based on national law, you just have to replace agent with counsel, because agent is usually used when it comes to international law competitions, especially when it comes to competitions before the International Court of Justice. All right, so that would conclude the first part of how to excel in court setting mooting. Now, the second part would be structuring oral arguments. And this is also really important. Firstly, it's very important to provide a roadmap. Now, Maryam has mentioned this as well, because it's equally important not only in arbitration, but also in court setting mooting. I think roadmap is something which is really mandatory, because it gives the judges the idea of what you're actually presenting. It's like giving an outline in your written assignment. So roadmap is essentially telling the judges what your submissions are. And in other words, what are the decisions you would like the judges to render and the reasons for that. So as a general rule, when it comes to submissions, you would want to pick at least 2 to 3 major reasons supporting your submissions. So usually in a court setting mooting, there would be at least 3 to 4 legal issues. So for each issue, pick at least 2 to 3 points or major reasons supporting your submissions. Now, I have a sample here. So here, the sample, the first submission would be the first issue. So for the first submission, we submit that this court has jurisdiction over Adawa's claims because Adawa is a party to the Treaty of Bottega. Your Excellencies, there are 2 points under the first submission. Firstly, Adawa is a party to the Treaty of Bottega because it continues to be enforced after the dissolution of the AZU. Secondly, Article 6 of the Treaty of Bottega confers jurisdiction to this court. So if you see the 2 points under the first submission, firstly and secondly, these are reasons that support the main submission, which is the first submission, which is that we submit that this court has jurisdiction over Adawa's claims. So this is extremely important, because by giving a roadmap to the judges would be writing this down and would be expecting to hear the points from your roadmap, and it makes it very easy for them to follow your arguments. So it is very important to have a roadmap when it comes to any mooting competition. Now, moving to the second tip when it comes to structuring oral arguments, it's very important to use plain English. Now, what I mean by plain English is to use short sentences as possible to keep your submission simple and concise. The best submissions are usually the ones that are very simple and easy to understand. And it is better to avoid the complex sentence structures and impressive words that may be too long to pronounce or may not be necessary at all when there are simpler words to be used. Another thing is that you should refrain from using legal jargons. Instead, explain them in simple terms. So usually what I personally like to do in mooting competitions is that whenever there is a term which I feel that a judge may not necessarily be familiar with, I would replace that term with something which is much easier for any commoner or layman to understand. So I think this is really helpful so that judges can really understand my submissions, even though they are not used to that particular area of law. So being simple is really important. Next, it's very important to pay attention to your tone. So this would mean that you should use different tones to continuously attract the judges. To do so, you would emphasize on certain important words or even phrases, because there are certain things which you would like to emphasize because they are more important than other words. So using different tones would definitely help that. And another aspect about your tone when it comes to mooting competitions is to avoid being dramatic. This is because some issues would concern the death of a person or the shoot down of a plane when it comes to international law issues. So in such issues, you should not smile too much because that would be dramatic. And at the same time, if your client rights have been violated, you shouldn't be too timid and too passive. You should be more firm. So you should really look at the facts of your problem and which side you're representing, and then consider the tone and the approach you'd like to take depending on the side you're representing. Another thing which I feel is important is the pause. Now, after each point of submission, meaning after you give each reason for your submission on why your argument should succeed, I would advise everyone to take a short pause, because it helps judges realize that you're starting a new argument, and it gives them a bit of time to digest whatever that is being said, and it gives them time for them to ask you a question. So using the pause is really important, and you can even try this in your oral presentations when you join degree later on, just to see how effective it is. But although I say use the pause, don't pause after every single sentence, because I've seen some mootes do that, and it does not really look good when it comes to oral submissions. Only use it when you are moving on from one point to another, but not after every sentence. So moving on to the third part of how to excel in court setting mooting, that would be responding to your opponent's arguments. Now, Maryam did mention that you should be respectful with your opponents, and that is something which I definitely agree. So if you would like to disagree with your opponent, you shouldn't simply just tell the court that they are wrong or they have lied. This is not proper, because in a court setting mooting, formality is really important. So how would you then tell the court that your opponent is wrong in a nice way? So what you could do is that you could take the argument of the opponent, which you believe is wrong, and then summarize that argument and tell the court that it is our respectful submission that the respondent has misconstrued the position of the law. So by doing this, you are still maintaining formality. At the same time, you're trying to tell the court that they have erred when it comes to the law or when it comes to the fact. And make sure that when you claim that the opponent has indeed said something wrong, you have evidence to back it up. Because I remember watching a mooting competition. It was the NAMCO competition in 2000. I'm not sure if it was 18 or 2019, but in the finals, one of the oralists just claimed that the other side was wrong, and one of the arbitrators immediately asked her, "What proof do you have? Because if you don't have proof, you can't make that statement." So I think it's really important when you're about to make such a huge claim, you have evidence to back that up. Next. Inserting rebuttals in your submissions. So when it comes to inserting rebuttals in your submissions, this is different from rebuttals after both teams have presented their arguments, which I will address after this point. So usually this point applies for the applicant. So the applicant is usually the party that will present the legal arguments first, and then followed by the opposing team, which is known as the respondent. So usually in the applicant submission, you have the claims that you will make to the court. On top of making your claims, you can also make a rebuttal in your argument before even the respondent has made the submission. So this is known as preempting. So basically, you are dealing with the possible arguments that the respondent might argue before they even come to the podium and present their arguments. So by doing this, you are essentially making their argument look weak before they even submit it, which is quite a good thing because it can give you the advantage in some situations. So, for example, as an applicant, you would say that the respondent might submit that they can rely on the defense of self-defense to justify their actions, but they cannot do so because it does not fulfill the requirements of self-defense. And then you explain the requirements and whatnot. So sometimes you may not have the time to do this. It depends on a case-to-case basis. But whenever you have the time to do this and you feel that doing this may be advantageous to your position, then I think you should do this. It's quite helpful. Thirdly, when it comes to responding to your opponent's arguments, this is the rebuttals and rebuttals. So I explained earlier that in a court session mooting, party one will present their oral arguments. The two oralists will present. After they are done, party two, which is the respondents, would present their arguments. And once they're done, there would be a session of rebuttals and rebuttals. Now, normally rebuttals and rebuttals would last between 2 to 5 minutes, depending on the team. Sometimes some teams would prefer to have 2 minutes for rebuttals because they feel that they can do it in a short period of time. Some teams would go for 5 minutes. Usually I would go for 5 minutes just to make sure I have enough time, because sometimes I like to speak slower than normal when it comes to mooting competitions. So I feel like I might take some time when it comes to rebuttals. So what do you say in a rebuttal or rebuttal? Now, rebuttals firstly are for applicants and rebuttals are for respondents or the opposing party. So when it comes to rebuttals, you are basically pointing out what the respondents have erred in the submissions. So you are responding to what the respondents have said in their submissions. And usually you would highlight the mistakes they have said or any consistencies they have made between their arguments, because you have to remember there are more than one legal issues in a problem. So sometimes there can be inconsistencies between one issue and the other. Rebuttals is meant for the respondents or the opposing party, and the rebuttals are for the respondents to respond immediately to the points made in the rebuttals by the applicant. So usually it's a bit difficult for the respondents in the sense that they only have a very short period of time to prepare for the rebuttals, but most of the time the applicants most of the time you can already preempt what would come out in the rebuttals just by your training sessions between your teammates. You can be able to tell that what are the possible rebuttals and rebuttals. So this is something you can train in your sessions. And the best rebuttals and rebuttals are usually short and snappy. This is an advice which I got from one of my seniors who taught me that when it comes to rebuttals, it's better to be very snappy and short and not to take too much time explaining the law, because this is not the time where you'd like to reiterate your position. It's a time where you would like to attack the opponent's argument and bring it down in the quickest way possible, but at the same time in a way which would hurt their position. So that would be all for responding to your opponent's arguments. Now, moving on to part 4, which is answering judges' questions. Now, Maryam did say that answering judges' questions contains a lot of marks when it comes to arbitration competitions. This is also the case when it comes to court setting competitions. If I'm not mistaken, there's at least 20 to 30 marks out of 100 allocated for answering questions. So when it comes to answering questions, there are 3 important things which I would like to highlight. Firstly, it's how to answer yes or no questions. The reason why I put this here is because from attending a few mooting competitions, most of the judges I hear in their feedback always talk about this, and this is something which I feel students don't really pay attention to, and it really makes a difference between two good teams in a round, and the judges need to make a decision as to which team has won. So um, usually yes or no questions are questions like didn't this court said this, or is it true that this happened. It's questions where you would respond with yes or no, but usually we don't really respond with yes or no. We would go a bit astray from the question and divert from the question and then later respond properly. So the most important thing is that whenever you hear a yes or no question, always respond with yes or no first, even if it hurts your position. This is because after you respond with yes or no, then only you may include the reasons why you said yes or no. The reason why is because sometimes judges just would like you to reply directly, and they know that asking that question would hurt your position, but they would like to see that even though you reply directly, you can still explain why it won't hurt your position after you have said yes or no. So I've put an example here. So a question that would be posed by the judge is, for example, counsel, you have proved requirement 1 but failed to prove requirement 2. And didn't this court said that there must be proof of requirement 2? Now, a bad answer would be not directly answering the question, would be like the example I've stated, which is, well, it is true that the court said that blah, 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 blah. So here you can see that the statement here is not directly answering the question. But a good answer would be answering with yes or no. As I stated here, yes, and then you explain the reason. However, numerous other cases show that there's less emphasis on requirement 2. So always remember, when it comes to yes or no questions, answer with yes or no first, and then only provide your reasons. And this will really help you gain more marks when it comes to answering judges' questions. The next part about answering judges' questions is to have structure in your answer. Now, usually when judges ask questions, we are not prepared for it because it's not part of our script. But even if that's not the case, we should always maintain structure in our answers. So usually when judges ask questions and we have more than one reasons to support our answer, what we can do is, for example, say that, Your Excellency, there are two responses to that question. Firstly, what is the reason? And then secondly, what is the reason? So structure is really important, not only for your roadmap, but also in answering judges' questions. Next, I would like to cover hypothetical situations. Now, the reason why I put this here is because many judges, from what I've watched in mooting competitions, even in the competitions I've participated, they love to ask hypothetical questions where they would give you a completely different scenario from the set of facts in the moot problem. And then they would ask you, what would be the position of the law in such situation? So the reason why they ask you this is to test the limits of your law and to make it seem that whatever you're submitting may not be the right law or reasonable, but it's usually very different from the set of facts in your moot problem. So what you have to do in such situation is firstly apply the law to the hypothetical situation, and then always distinguish it with the facts of your current case. So you could say that yes, it is true that by applying the law to the facts you have stated, the result would be this. However, this is not the case in the current moot problem. This is because of the facts of the case. So in such situation, answering hypothetical questions like that would be ideal, and it would be really good because it would show judges that you're actually you actually know the law, because you can not only apply it to the facts you have in your problem, but also to any other form of facts that is not in the moot problem. So it really shows that you have knowledge of the law. now we would move on to the last part of the how to excel in court setting mooting, and that would be time management. Now, in most mooting competitions, there are at least 15 marks allocated for time management, and many mooters do not really finish the submissions within the time limit, and this is where they lose a few marks. So my advice is to always practice presenting your legal arguments within the time limit. So what you can do is just that you could use your phone, open your stopwatch app, and record yourself submitting and see how much time you have exceeded. And from there, you can tweak your submissions to make it much shorter so that it does not exceed the time limit. And in some situations where if your time is up and you just wish to have a bit of time just to explain a few things or to wrap or to just quickly summarize the last point, you can ask the judges to give you some extra time. For example, you can say, Your Excellency, I see that my time is up. May I request for a short extension of time to conclude my submissions? In most cases, the judges will grant you an extension of time, but not too much, usually 1 to 1.5 minutes, nothing more than that. So you can do that if you need more time. Now, another point is that it's not necessary for you to use up the entire time allocated in your submission. So for example, if in your introduction of your speech, you say that I will be taking 20 minutes of the court's time, and you finish your submission in 15 minutes. It is perfectly fine to do so because it has happened to me before where I've allocated 20 minutes, but I've managed to finish in 15 minutes. And there's nothing wrong with that, unless you would like to elaborate more on certain points in your submission. And lastly, even if you're running out of time, try not to speak too fast because sometimes when we see that the time is running out, we tend to rush things and we speak much faster than normal. And when we do that, the judges would notice that the mooters are rushing, and usually the judges would be put off by that and would not listen once the mooters have rushed. So try to always remain composed and speak slow no matter what the situation is. And even if the judge is bombarding the mooters with questions and not letting the mooters finish, they would remember that they have asked a few questions and they would not be removing marks or giving penalty because you have not finished your submissions. So this would be almost the end of my almost the end of my presentation. I would like to give a list of court setting mooting competitions followed by a video illustrating one of the competitions. So when you join ICOL in your degree, there are a few competitions which you may join. So firstly, you have the Philip C. Jessup International Law Moot Competition. So this competition is a competition that is based on public international law. And in this competition, usually there are many different areas of public international law. It depends on a yearly basis. This year, it's about COVID-19 and shooting down civilian aircraft. Last year, it was about autonomous weapon systems. The year before, it was about hunting animals for medical purposes. So every year, the issues are different. And usually in this competition, there are issues which are current, and at the same time, there is no proper law for this. So usually it's an issue which is developing, such as, for example, the COVID-19 situation. So this is one competition which you may consider when you join your degree. Another competition would be the International Humanitarian Law Moot Competition. Again, this is also part of public international law, but a specific area of public international law, which is international humanitarian law, which is the law that governs situations of armed conflict, usually in times of war. And this competition is, in a way, the Jessup competitions also have issues of IHL, but the International Humanitarian Law Moot Competition is exclusively on IHL. So everything that is in this competition is only on IHL. Unlike the JESIP competition, where you might have one issue on IHL, another issue on human rights, another issue on COVID-19, another issue on weapon systems. So that would be the difference. And then another competition would be the Tun Sufyan Constitutional Law Moot competition. So this is a competition where there would be issues of constitutional law, local, national constitutional law issues, and it's usually on every other year. They would swap out they would have either a constitutional law moot court competition by Tun Sufyan or a human rights moot competition. So last year we had last year we did not have last year we did not have any competition because of the COVID-19 pandemic. But the year before it was on human rights, so perhaps the next one would be on constitutional law. Next we have cyber law moot competition. So cyber law moot competition is actually a competition that is organized by IIUM itself, but there are other teams that are involved as well. Now, in this competition, there are issues relating to cyber security and also issues relating to constitutional law, obviously to see whether the provisions of certain act are constitutional or not. And this is quite an interesting competition because this area of law is something which many lawyers would be looking into in the next few years. So I would advise students to also check out this competition as well. And then we also have the Price Media Law Moot Court competition. So this is a competition that is also part of public international law in a way, because it's about the media law and human rights relating to media law, such as freedom of speech and expression and whatnot. Usually URA does not compete in this competition, but hopefully this year or next year, URA would be sending a team for this competition. Lastly, one of the court setting mooting competitions would be the Ahmad Ibrahim Internal Moots competition. Now, this is a competition for only ICOL students. So if you're not really sure whether you would like to join competitions competing with other universities and you just would like to test whether mooting is for you, you can join this mooting competition. It's a really good platform for you to get started because you would be with your friends and you would be competing with your other friends as well, and the judges would be seniors and perhaps even lecturers you'd know. So it's actually a quite fun competition to be a part of, especially if you're starting out mooting. So before I end my presentation, I just would like to share a short video of a court setting mooting competition. We'd probably watch just the first 2 minutes, and that's all because it's quite long. So this is a competition which was in 2005. It is the Philip C. Jessup Moot competition. And in this competition, IIUM went to the finals all the way in Washington, D.C. And one of the mooters from IIUM, in fact, was awarded the Best Oralist Award. And this is quite a big inspiration, I feel, to many mooters, especially myself. And this was the first actually mooting video which I watched before I even joined a mooting competition. And I really advise everyone to later, whenever they're free, just go on Google and type Jessup Moot Competition 2005 IIUM. So hold on, let me share my screen. All right. So the mooter that would be speaking now is Madam Siti Aliza. She was my lecturer for compulsory moots. She's no longer with IIUM because she went to pursue her PhD, but this was her in the Jessup Moot competition in the finals. Hold on.
May it please the court. My name is Siti Aliza alias, appearing on behalf of the respondent, the Kingdom of Raglan. With me is my co-agent, Ms. Malati Abdul Hamid. and Table Counsel Mr. Ng Boon Ka. Your Excellencies, me and my co-agent will each be taking 21 minutes of this court's time, and we reserve 3 minutes for rebuttals.
Yes.
Your Excellencies, I will be dealing with two issues. Firstly, regarding the scuttling of the Marimaru, and secondly, regarding the piratical attack and piratical activities in the archipelago. And the other two issues will be dealt with by my co-agent. And I shall begin with Raglan's first submission, that it is not responsible for a breach of international obligation in the scuttling of the Marimaru, because the scuttling of the Marimaru was done due to exceptional circumstances that justify its action. Your Excellencies, the Kingdom of Raglan is invoking its right as a coastal state to take defensive enforcement measures upon a foreign vessel on the high seas when there is a threat to the interests of its coastal nation, Your Excellency. This right, known under international law as a coastal state's right of intervention, is a rule of customary international law. This is because
What sort of threat? You put it at a rather low threshold when there is a threat to the coastal state. Does it not have to be rather more than that?
Your Excellency, according to the Intervention Convention, the threat must be an imminent threat. But according to UNCLOS, merely a threat to the coastal state and or its related interests. But we will prove to this court that there was an imminent threat. Firstly, I shall establish that the rule on intervention itself is a rule of
All right. So thank you, Brother Muhannad and Sister Maryam. So maybe to conclude, from my understanding, I think arbitration setting is more about dispute resolutions because you have plaintiff, defendants, and arbitrators. But especially for court setting, you have actual judges. You address them with your excellency. But all in all, both require you to be polite and concise, especially in the oral submission. All right. So basically we're already in the halfway of the program. So we will take a short break first. So see you again in 10 minutes. Thank you. All right. Assalamualaikum and welcome back everyone. Thank you for remaining here with us in today's Lex Moot. So inshallah for next session, I'll just cut the chase and invite Sister Hashima for the client consultation. Please welcome.
All right, I'll start by sharing my screen first. Can you guys see? Is it there? All right, cool. So, Assalamualaikum and a very good day. I am Hashima. I am currently in my third year, first semester, going into my third year, second semester. I joined client consultation when I was in my first year, and I've been helping the team since then. So now, I think to start, the right question would be, what is client consultation? So when I first heard about client consultation, honestly, I was, very clueless as to exactly what it is. I think during my time before I joined the team, there was no one who actually properly introduced and explained to me what is client consultation all about. So the goal for today is for me to introduce to all of you here what is client consultation and to give you an early exposure and to show you that once you enter your degree life, once you enter ICOL, there's more to explore than simply joining societies or debating, etc. If you are a law student, it would be a life-changing experience if you could actually join law-based competition that we offer, and one of them being client consultation. So to give you like a clear picture of what is client consultation, I'm going to start with a question. So what are lawyers, advocates, solicitor, you name it, what are they famous for? They're famous for arguing a case in court for the client. They are famous for representing the client in court. So you see, the main duty of an advocate or a solicitor is to actually cater to their client. But the question is, how do we cater to our client if we don't have a client in the first place? And I can assure you, in your 4 years reading law in ICOL, there is hardly an opportunity for you to be able to learn this necessary skill to ensure that your client actually hires you as their lawyer, as their representative. And so this is when client consultation comes into the picture. The legal profession, right? It's not merely about winning a case in court. That is, true, but that is at the other end of the spectrum. At this end of the spectrum, it's a whole another story and it's a whole another skill set. So if I can describe client consultation in a few sentences, I would say that it is the first stage in offering a legal service to your client as a lawyer. Before you can bring any matter to court, you must first consult with your client. So you must possess the necessary skill to understand your client's legal problem, legal concern. From there, you identify the legal issues and then provide legal advice during the first legal consultation itself. So the emphasis here is the first legal consultation. What do I mean by this? Now, it's equivalent to first impression. When a client comes to you for the first time and then present their problem to you for the first time, you've never heard of this problem, you've never got the chance to analyze it, to do a research about it. Now, can you say at this point to your client, can you say this? Can you say, can you give me a few days, in a few weeks? I'll come back to you and I'll give you advice. Of course not. You are expected as a lawyer later to be able to analyze the legal problem, extract the legal issue, and give legal advice on the spot. So first impression during the first legal consultation matters to ensure that they trust you enough, they trust your capability enough to hire you as a lawyer. And this first legal consultation is what is tested during the competition. So question is, what is client consultation competition? It is a competition that stimulates a law office consultation. So participants, which are law students, will take the role of lawyers, and on the day of the competition, they'll be presented with a legal concern and on the spot from the client. And the law students will then have to come up with legal advice. So generally, what they will be assessed on is how well they deal with the whole session of the consultation. So now, what is the objective of the competition? Now, obviously, any competition, the objective is just to win. But besides that, it is also important to, the competition is also there to expose the students to the art of communication, listening, questioning, analytical, planning skills, and so on. So firstly is communication skill. So if you were to join client consultation, you would be able to acquire communication skill. I'm not talking about any type of communication skill, because being a law student, I think we hardly have a problem communicating. But question is, can we actually communicate in a lawyer's, can we actually communicate? Oh, wait, sorry, did you actually get the slides before? Was it stopped just now? Yes, sorry, as in what? Is the slides? It is fine, okay, cool. I'm just worried that I'm not sharing the slides. Can you inform me if I'm not sharing the slides? Okay. Okay, cool, sorry. So I think, where was I just now? It was, communication skill. So the question is, do you actually have the communication skill to actually talk to a normal person? Because being a lawyer, right, you have to communicate and be able to negotiate with ordinary people. What we call ordinary people, is layman, meaning you have to be able to communicate with laymen. If you want to consult with a client, you need to possess the skills to translate your legal knowledge and your legal jargon into layman's term. Because at the end of the day, lawyers, they deal with everyday people who usually have little to no knowledge about the law. So you may think it's easy, but I can assure you, being a law student, we have actually forgotten how to speak like normal people. So this is one of the things that you will learn, in client consultation. So next is, you will also be able to learn listening skills. So I'll give you an example, right? So let's say if your friend comes to you and they start sharing with you their concern. Now, it wouldn't be so hard to listen, right? But when a client comes to you and share their concern, it's a whole another story, because you not only have to listen, but you have to also do every other thing at the same time. So for example, you have to listen, but at the same time, you have to take down every single detail whilst maintaining eye contact with your client. So you have to ensure that you wouldn't want to miss any facts, because you missing a fact would change your whole legal issue. It would change your whole legal advice at the end. So yeah, and then another skill that you will learn is questioning skill. Now, unlike your friend who would, simply share their whole story from A to Z, when a client comes to you in real life, most of the time they are as clueless as you are. They do not know which part of their concern, which part of their problem is important to share to their lawyer. When a client comes to you in the competition, they wouldn't share their concern with you until you ask the right question. So questioning skill is all about asking the right question at the right time, with the right word, with the right tone, and with the right facial expression. So yes, besides listening and simply questioning, there's so many other things that you have to take into consideration, and it's a skill that has to be sharpened. So another thing that you will also learn in client consultation is you will develop an analytical skill. And now I think all of these skill sets are, you are going to be able to learn it in law school and in other competitions. But in client consultation, it's a bit different in the way they assess, this kind of skill. So for example, analytical skill, right? So once you've asked questions to your client, You have to listen to the answer, you have to note it down, but on the spot, you are expected to give a legal advice. So the part where you analyze the legal problem, you analyze the legal issue, happens simultaneously when you are actually listening and questioning your client just now. When you're actually listening and questioning your client just now. So because it happens on the spot, it happens impromptu, it really tests whether you are able to analyze things on your feet, whether you're able to think on your feet to analyze all of these things. Because being a lawyer, right, not always do you have time to go back home or to go back to your office and do research for weeks, for months before giving advice. Sometimes you are put on the spot, right, especially during the first legal consultation. You're put on the spot where you must use your advising skills to actually give an advice, and your advising skill must come naturally with you. Sometimes it does not require you to do months and months of preparation. Your client wants to see whether you are able to be their lawyer during that first legal consultation. So you have to be able to have a good first impression, and to have a good first impression, you need to be able to have good advising skills. So lastly is planning skills. So client consultation doesn't stop at just simply giving legal advice. It also extends to train you how to then provide an action plan for your client. So what do I mean by this? So clients are ordinary people, right? So they don't know about legal procedure. When they come to you not knowing what is the next step that they should take. So as a lawyer, you are then expected to give a layout plan to your client, explaining to them that currently you are at this stage. And at this stage, here are your options. If you were to choose this option, this is your next step. If you were to choose this option, this is the consequence. So this is what all of the things and some of the things that you will be able to learn if you were to join client consultation competition. Now, right, format of the competition. I do not want to dig into details with regards to the format of the competition, but I think this is enough to actually, what I will be giving you is enough to give you a brief overview of how the competition will be conducted. So first is, what is this competition all about? Now, the competition, I think I've mentioned this 1,000 times, it simulates a law office consultation in which two law students will take the role as lawyers and they are presented with a client matter. Now, now comes the interesting part. Now, I keep on saying, client. What does client actually means? Now, client is basically the person, client is the person that will take the role of a judge. They will not be judging you, but they will be questioning whatever that you presented to them. So usually a competition host will be responsible for selecting a client. So for example, let's say if UKM were to host a competition, then UKM will get another law student to act as the client. Now, when we as legal counsels meet our clients, we meet them for the first time. So we do not know exactly what is the legal problem that they bring in with them. So everything is for the first time. So that is why this whole competition is very impromptu in nature. So when clients come to you, they are usually assigned with characters. It comes with different personalities. For example, a client has to take the role of an old lady. So an old lady comes in, and an old lady is assigned with a personality that is, she has an anger management issues. So now you have a client who is an old lady with anger management issues. Now, what the judges will assess you on is that the judge will assess you on how do you then consult and negotiate and also give legal advice to this type of client. So this is where I would say the fun part of client consulting, but it's also equally challenging. So just to give you a better picture of how the competition is, so this is what I mean when I say there will be two lawyers and there will be one client. So as you can see, two lawyers will act as the legal counsel, And then there will be a client that comes into the law office simulation. So let's move on to the team. Now, when it comes to the team, there is actually 3 law students, 3 participants that will actually represent the university. So 2 of them will take the role as counsels, and 1 of them will actually be the researcher. But in actual reality, the research team is more than 1 person. It is more than 1 person. As you can see from this picture, although the 2 counsels are considered as the oralist, but backstage there are a lot of more people who actually help the team to actually win. So as you can see, this is this now was during my time, and this was more recently in 2020. So now let's have a look at judges. Now the judges in client consultation competition is different from mooting. For example, when in mooting, what you have to do is that you are actually answerable directly to your judges. It's in mooting, right? But in client consultation, the judges will actually be silently evaluating you. So you won't be answerable to the judges, but you will be answerable to your own client. So the judges can come from people who are from different fields. Some of the familiar ones would be court judges, lawyers, and experts from different fields. So experts from different fields can come from people who are experts in the field of psychology, for example, because when you deal with clients, you deal with their emotions, you deal with people. So they will assess how are you actually able to deal with people. So what will they judge you on? They will judge you on a number of criteria, but these are just some of them that I'm showing to you for today. But some of the things that they will judge you on is they will judge you on firstly on your understanding of your client's problem, because I've mentioned before that when you step into the competition, you have no knowledge at all about your client's legal problem. You have to be able to understand your client's problem on the spot, on the day itself. So your ability to understand your client's problem will be assessed on. And then your ability to learn what is your client's goal, what are their expectations, what do they actually need will also be assessed on. And after all of this, you then will be assessed on how do you outline and how do you analyze your client's problem and whether you provide a relevant and accurate legal advice at the end of the day. And how do you actually assist your client to make informed choices? And they will also assess you on your teamwork. And it's very important because in client consultation, you actually have 2 counsels, like I've shown you just now, right? And during the day of the competition, there is no too little interaction between counsels. So you must be able to work in synergy, to work together, to conduct the whole session without really interacting with each other. So that is why in client consultation, usually before you are selected to represent IIU, the trainers will actually pair you up and see which pair actually have good chemistry, which pair can actually work together. So they will change the pairing, every other day to see whether you guys can actually work together, because teamwork is, that important. Now, the competition topic or the area of law. Now, the area of law, when it comes to area of law, that will be tested. It can be anything. For example, it can be torts law, it can be contracts law, it can be criminal law. But for 1 year, there will only be one area of law. During my time, it was criminal law because it was criminal law. And because the area of law is so big, right? And you don't really get any clue what is the legal problem beforehand, they usually scope it down. For example, crimes related to property. You can scope down your area of research, when they have scoped it down for you. But it doesn't mean that your research is much lesser, because although they have specified that area of law, for example, it's criminal law, but in actual competition, you will be tested on many other related laws, such as criminal procedure. And during my time, we have to do a lot of research on anti-money laundering law. So not only you'll be able to learn in detail and actually learn, not only you'll be able to learn in detail what you have already learned in law school, but you will be learning how to apply them. And you will also learn other fields of law that is also not taught in law school, Like, for example, anti-money laundering. It was not taught in law school. Another part of my presentation is I will also be explaining about the processes. Now, again, I only want to touch very briefly because I don't think it's very useful at this point of time to go very detailed. But this is how the processes go. Usually, the whole session is 45 minutes. So the first stage is the formalities stage. Now, formalities is basically the process when your client. It's basically the process that starts when your client enters the room until just before you ask them, why did they actually come, in the first place? Now, so how well you handle your client at this stage, is tested. So what is actually tested is your rapport building skill. So the rapport building skill is basically the process of how you build trust through a positive initial connection with a client when they come to you for the first time. So you need to be, at this stage, you need to be able to convince your client that you are genuinely concerned with your client's problem. You genuinely want to solve and help your client. And once your client trusts you enough, then only they will start to open up to you. Then only they would start to share their concern. And during the formality stage as well, we also are required to gather preliminary information. So preliminary information or information that, such as, for example, your client's full name, their contact number, etc., etc. So these are information that are preliminary before you actually go into the legal problem. And during this stage as well, usually we have to explain to the client, how the session will be conducted. You have to brief the client because they wouldn't know how do you wish to actually conduct your whole session. Now, the next step is probing. Now, this is where it gets a bit more challenging. There's a reason why we ask, you to build a rapport so that your client will, open up to you. But the question is, why do they need to open up to you? Now, before the day of the competition, you will only be given a memo. A memo is like a clue as to what is your client's problem. And the clue is just one sentence. For example, Encik Ali comes to you with a problem regarding his neighbor. That is all that is given to you before the competition. That's a one-liner, and then the area of law. So it's very important that to understand what is your client's legal problem, you have to complete the facts of the case yourself. And that is, done through probing, through questioning. So question is, what is the right question to ask? What do we actually have to ask? Because this is where it gets challenging, because when you have during client consultation, right, you have to do a lot of other things. You have to listen, you have to jot down, you have to deal with your client's personality, you have to negotiate with them, and at the same time, you have to know what is the right question to ask. And most of us always get stuck here because of the nervousness and everything. We usually get stuck as to what do we ask then. You don't want to not ask anything, because then it would be very awkward. The whole session would be very awkward, and obviously your marks will be deducted for it. So what we always would advise participants is to ask questions that are relevant to complete the facts. So the questions asked must be aimed to identify facts that will help you later to identify the legal issue. So always ask yourself, what is the legal element to establish a particular cause of action? And ask questions that are surrounding, that legal element. And the third step is to summarize and advise. So summarizing is, once you have questioned your client, meaning once you've obtained all the relevant information, all the facts, then you have to reconfirm with the client. So is this facts true? It's very important to reconfirm, because then you would have to use those material facts to give advice. So advising is when you outline and you explain the nature of the problem to your client. So after you have outlined and explained the nature of the problem, then you have to present your client with the means, the options, the alternative to resolve that problem. So the way we advise is similar to how we do advising in law school. That means we use the IREC rule: issues, relevant laws, application, conclusion. It's similar in that sense, but the only different thing is that you wouldn't have the time to actually plan out your IRAC. You wouldn't have the time to, think first, what do you want to advise? Because everything is done on the spot, so you have to think on your feet. And on top of that, you have to advise in layman term. So the goal in advising is not to flaunt your legal jargon. The goal is to show that you are a good lawyer, is to be able to make your client understand the legal issue and the law surrounding it, his or her concern. And your client won't be able to understand if you kept on using legal jargons, for example. And the last step is post-consultation. Now, post-consultation happens for like 5 minutes towards the end. It happens after your client have left the room. So it is some sort of like a reflection that is done between the two lawyers. This is the only time you can actually interact with your co-counsel. So during this time, both of you will use this time to acknowledge what is your strength, what is your limitations, what is the strength and limitations of your case before you end the session. Now, let's have a look at the types of competition that we have. Now, client consultation competition. Firstly, usually we have the internal client consultation competition. So this is usually organized by ICOL, and the participants are ICOL students. And then we also have the national competition, which is called the Harun M. Hashim National Client Consultation Competition. This is where you will represent IIU. And then if you were to win during the national competition, you get to represent Malaysia internationally in Brown Moston International Client Consultation Competition, which is usually conducted abroad. So now I think we're moving towards the end of this whole session. So I would just like to share a few pictures of past competitions, past participants. So firstly, we have in 2014, where IIU actually represented Malaysia in the international competition that was conducted in Puerto Rico. And then we have another team that also represented Malaysia in 2016 in Canada. And this team also actually represented Malaysia in 2015, but I couldn't get a picture. So, and we also have the teams that represent IIU in the national competition. This was in 2018, this was in 2019, and this was in 2020. So, and this was very recent. This is the ICOL Internal Client Consultation Competition that we had back in December this year. So yeah, that is all for me. Before I end, what I have shared, since most of you are still in CFS and those who are listening to this broadcast right now, I would like to say that you guys are, very blessed with this opportunity to be given, this early exposure early on. You have been presented with a lot of options to choose from. So my advice is never feel like it's like too early for you to join any competitions or feel like you're not ready yet. Don't ever say that, oh, I'll try later in my 3rd year or in my 4th year, because trust me, you'll never be ready at any stage until you try. So at least if you enter early on, you would have more time, to prepare. So seize every single opportunity during your degree life, because each one of them, I think, will be very, very valuable later on. So yeah, that is all for me. Thank you.
All right. Thank you, Sister Hashima, for the sharing on client consultation. Maybe to conclude, I would just want to highlight that to be a good lawyer, it is not all about using tons of legal jargons and bombastic words, but maybe the key is to have the effective communication with your clients, especially in explaining using the layman terms. All right. So next, I would like to invite Brother Rauf for the very last session before the Q&A part. So please welcome.
Okay. Assalamualaikum warahmatullahi wabarakatuh. Can everyone hear me? Okay, so I'll share my screen. Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. So, just a brief introduction. I am Muhammad Rauf, a fourth year first semester student, and we'll be going into my final semester next semester. And I've participated in the International Humanitarian Law Roleplay Competition 2019, the national round, and both of IIUM teams managed to go into the semi-final. So now let's move on to what is IHL Roleplay Competition. So IHL Roleplay Competition is a competition also organized apart from IHL Moot competition. This is also another competition organized by the ICRC, International Committee of Red Cross. So we have national round, regional round, and also international round. But the international round is called the Jean Pictet, which is usually usually and recently they would organize it in Bali and also in a European country. So moving on, IHL Roleplay competition is to me, I would say it's a competition of one of its own kind, because and it is a relatively new competition, because the first competition or the first edition was back in 2015, and we only participated in the second edition in 2016, and towards then we have managed to send representatives every year. And before I move on to what is International Humanitarian Law Roleplay Competition is, I think it's important for me to just briefly share with you what is International Humanitarian Law is. Because this is very, I think during my time back in CFS, I don't even know what is IHL Roleplay Competition, what more IHL is about. So international humanitarian law is a field of law that governs the situation during an armed conflict. So it is also called as laws of armed conflict or laws of war. Okay. So this is just a technical definition, which is a set of rules which seek for humanitarian reasons to limit the effects of armed conflict. It protects the persons who are not or are no longer participating in the hostilities and restricts the means and methods of warfare. I think it's important for you to embody this definition during the competition, because it really revolves around this, which is you being someone or individual who wanted to limit the effects of armed conflict and to protect persons who are not participating, meaning that civilians or innocent people, and people who are no longer participating in the hostilities might refer to militaries or medical personnel. Militaries who are no longer participating, meaning they have conceded defeat or maybe they were injured. So these people need to be protected. And on the restriction of the means and methods of warfare, this competition will assess you on how you restrict the means as in the weapons used. You might want to say that this weapon can be used, this weapon cannot be used, based on what law, based on what provision. And methods of warfare refers to the tactics or strategy used by the parties in the war. So IHL and public international law. So like what Brother Muhannad Munir had said in his previous presentation just now, IHL is part of international law or public international law. So international law governs relations between states, and it must be noted that IHL only applies when there is conflict. So the question of whether a state may actually use force is not governed by IHL, but it is governed by public international law in general. Because under IHL, we acknowledge that to a certain extent, war might arise. armed conflict might happen and force might be used. But IHL is there to restrict the effect, not to cause superfluous injury and unnecessary suffering to the parties involved in the war. So along the presentation, I think it's important also to share with you the history of international humanitarian law, which goes in line with the history of establishment of ICRC, which is the main organizer of this competition, ICRC, International Committee of Red Cross. So in 1859, back then, there was a battle named Battle of Solferino between French Sardinia against Australia. And so during this war, it was very bad, it was catastrophic. 230,000 to 300,000 soldiers fought in the battle. And it was really barbaric in the sense that there is no rules governing what happens during that time, during that war specifically. So there is a man named Jean Henry Denon, or we call him Henry Denon. He was there for a business, but then when he saw and went through the place, he was shocked and sad to see that there were 23,000 people wounded, dying, and that people were left at the battlefield unattended. There were no medical personnel helping the people injured. So he then organized the civilian population to provide assistance to the wounded and to the sick people, and organized purchase of medical supplies, materials, and help erect makeshift hospitals. And then he succeeded in gaining the release of Austrian doctors captured by the French. So what happens subsequently, he wrote in his book, In the Memory of Solferino, quoting in verbatim, could not voluntary aid societies be founded whose function would be to provide or arrange to provide help for the wounded during wartime? So this what had inspired or caused him to establish International Committee of Red Cross, ICRC. So Denon traveled around Europe to promote his ideas and was well received. So this was the founding fathers of ICRC. There were 5 people. Before that, ICRC is not an NGO, it's not an international organization, but rather it is a private agency. And like I said, from ICRC then IHL also was born. Okay. So when does IHL apply and what does it cover? So IHL, as I've said just now, it only applies during armed conflict, during war. So it could be during international armed conflict or during non-international armed conflict. So that is, you would have to figure out during the competition whether the situation that they give you is an international in nature or a non-international in nature. So it happens as soon as the conflict began. So, and it applies equally to both sides because ICRC and IHL does not side to any party. It's just there to serve justice. And what does it cover? As I said, it protects a person who are not participating and are no longer participating in the fighting. And it also restricts on the means and methods of the warfare. And okay, so from this, when ICRC was established, they then convened and meet a meeting to establish the Geneva Conventions, which is the main resources for international humanitarian law. So there are 4 Geneva Conventions, and also there are 2 additional protocols. These provisions are heavily referred to and used during your time of competition. So any argument that you use, it is really useful and it is really convincing if you use these provisions of Geneva Conventions and also additional protocols in your argument. apart from the main resources, we also have the other agreements listed down there. And this list is not exhaustive. There are many conventions that govern the international humanitarian law. And recently, even we have the Treaty on Prohibition of Nuclear Weapons. So it's nice if you can have a read or research on that contemporary issues. And but it is also to be noted during the time of the competition, a convention only applies if a state or country ratifies the convention. So this you will learn during your degree years later in ICOL. So do not worry. I think IHL is very fun and very interesting subject. So now we have come to the roleplay competition. So what is IHL roleplay competition? It is okay. To be honest, during my time of competition, I had no idea what IHL roleplay competition is, because it's weird, right, to know that there is such a competition named roleplay as a part of Moot and CC competition. So I think it's not weird to think that it is a performing arts sort of, but it's actually not. It's actually more of it's like CC, but I guess it is more laid back, but it doesn't mean that it is less challenging. So it's simulation based. So they will give you fictitious case study related to IHL. Although it's fictitious, usually they would give you the case study based on real situation that is happening or that had happened in the past. So during my time, I think they were referring to during our training, we usually make the simulation for the training to based on real situation that is happening, so that we would be prepared for the competition. So as the name of the competition suggests, we would be given or assigned roles such as ICRC delegates, militants, UN, United Nations officer, or humanitarian officer. And this list is also not exhaustive. You could be anything. You could be a medical personnel. You could be a terrorist. You could be a civilian. The possibilities is infinity. So now we've come to the format of the competition. So the competition comprises of the team comprises of 3 persons. So all of them are speaking members, and this is what makes it unique, because some competition they might have a person who is called an anchor. An anchor is someone who must know the argument of both sides, either the plaintiff or defendant or claimant and respondent. But for IHL roleplay competition, all 3 members equally contribute to the group. Yes, and we also have outdoor and indoor simulations. Usually they would start the competition with an outdoor simulation and continue it with indoor simulation till the final stage. So what do we do during outdoor simulation? Usually we would be assigned the roles of ICRC delegates to go into a war or an armed conflict area and to gather information, and also to help the injured, and also to report back to our superiors during the second stage. So the indoor simulations consist of many kind of things such as negotiations, mediation, and the final round usually would be either mooting or arbitration. So the question will be received before the test. So the question is called simulation. So they will give you a brief that consists the facts and also what you have to do, what your roles are at that point of stage. And so they will also give you preparation time, and this preparation time varies from one stage to another. So for the outdoor simulation, you could be given 15 to 30 minutes, and even towards the final round, the preparation time would additionally increase as the stages advances. Also, that is on the each simulation for each simulation. But they will also give you a background, case background, a month before the competition. So this case background will probably consist of 5 to 10 pages. So they will give you the facts and even give you the maps of the competition or the situation, or even they would only give you the facts and you would have to figure out the map itself. So during our training, we tried to figure out the facts and create our own map to understand the case background better. And also they would give you a list of tables listing what conventions that each states or countries in that case background ratifies to. So next, round robin during preliminaries, knockout for finals. So for preliminaries, they will accumulate the points for you to advance to the next stage. But semi-final and final, they would use the knockout method. Okay. So types of situation. What makes IHL Roleplay more interesting is that each stage has different assessment, has different types of jury. There could be a bilateral jury team, whereby only the jury and also only one team interact with each other. There could also be a trilateral team, meaning that there is a jury, a group of jury, and also two groups presenting their argument to the jury. So it could be also in the form of group, whereby more than two groups presenting in front of a jury. And plenary is where all groups are gathered in a room. And another thing is that IHL Roleplay competition is not really about who is right and who is wrong, but rather it would be finding a middle, settlement, to reach a settlement between all the groups, and in order to protect the civilians, in order to protect the injured and the sick. So that is your main concern, not to win your argument, but rather to protect, to be human. So like I said, this competition involves a lot of things. It involves fact-finding and reporting, mainly or mostly during the outdoor session, because I'll show you the pictures later to understand better how the fact-finding and reporting applies during the outdoor simulation. So the negotiation, and in fact, during the indoor simulation, we would have a simulation where we would have to interpret or draft laws and policies. So your role would be a legal advisor of a country or a party in the war. And also you could be in a meeting giving legal advice to the rulers, whether to attack this country or not, whether to defend yourself and whatnot. And lastly, usually they would give you the court setting or arbitration during the final round. So here is the picture of the competition. This was back in 2019 during my time of participation. So as you can see in the left picture, this was during the outdoor simulation. Both of these pictures are during outdoor simulations. So they were held hostages by the militaries, and this at this point of time is where you apply your negotiation skill, where you negotiate with the militaries and to go inside that place to know what is happening inside that place. So some groups even brought their own first aid kit to embody the spirit of ICRC delegates. And it's not easy because during my time they even confiscated my personal belonging, which is not part of the competition, which is my wallet that I brought during the competition. So it's better if you could bring less stuffs with you, so that it would be more convincing to show that you are an ICRC delegate that is only coming there to gather information, to help the sick and the wounded, and yeah, to convince the militaries. On the right side is the part of the outdoor simulation also, whereby this was at checkpoint. So during outdoor simulation, there are a few checkpoints. So this is one of the checkpoints whereby the militaries actually committed perfidy. So what is perfidy? Perfidy is the act or being untrustworthy. But in IHL sense, it refers to making up fake hospitals. So these militaries were making up fake hospitals to cover their activities, so that the opposing party would not attack their medical base, thinking that it was really a hospital, but in fact was actually used to store their weapons. So we would need to gather information from the people in there, and during the competition, you really need to rely on your creativity. So some of you might have to convince and distract the military. Some of you might have to go and interview the people there, such as the really injured people. And in fact, it was not easy because some militaries are really reluctant to give information, and even the innocent people, because they were scared, as in they were being held hostages by the militaries. So you really need to convince themselves that you're not biased, you are part of an international organization that is really just there to help and serve justice. Okay, so this was on the second day during the indoor simulation. On the left side is actually our team. So at this time, we were given the role of representative of ministry. So we would need to, decide whether a child soldier should be prosecuted or not. So depending on the role that was given, you would have to argue based on the international humanitarian law provisions and so on. So on the right side is the final round, whereby they did card setting or moot competition for the final round. So during this time, the question was whether they should attack or not a breach, because it could be the breach is supporting the enemy, but also the breach would then because the civilians were also using the breach. So you need to balance between the right of defending yourself and also the right of the civilians. So that is when you are being assessed. In fact, IHL Roleplay competition is very subjective. The assessment is very subjective. We don't know we don't really know what they were assessing us on. But one thing for sure is that they assess us. They assess mainly on our cooperation and teamwork. As I see it, it's not about who is right and who is wrong, but rather reaching a settlement between both parties to protect the right of the civilian and the injured. So I'm coming to the end of my presentation, and IHL Roleplay competition is to me very unique. It is a combination of a lot of things. It combines negotiation skills, it combines conciliation skill, mediation, moot court. So it's all in one. So it's really, and in fact it's more laid back compared to other oratory competitions. So it would be useful if you think that you are scared to go for moot court competition right away. You can try IHL Roleplay competition to to polish your skills first before going on to moot court and other oratory competitions. And just for your information, IHL used to be taught in public international law subject in main campus during our degree. However, now with the current the new updated study plan, international laws, public international law subject only have one course. We used to have two courses, which is taught in first semester and second semester. So now that we have only one public international law subject, IHL is not included. So, but no worries. During training, the trainers and the coaches will help you to understand better what is IHL all about. So you don't have to worry, and I think just enjoy yourself. And even if you are first years, don't be afraid, because as you can see in the left picture, on the right, most right side, Sister Umaira, she was first year, second semester during that time of competition. So she never ever learned or read about international humanitarian law, but that is not a concern, because we will learn together and the coaches will help you along the way. So I think that's all from me. You can always ask us at our Instagram and our email. Thank you.
All right. Thank you, Brother Rauf. So, Alhamdulillah, we have reached the very last part of our program. And I can say that the last part, IHL Roleplay, is very exciting. And I can see that I'm now taking sides whether to participate in IHL Roleplay or client consultations. But as for now, we will proceed with the Q&A session first. So, for the first question, is about what are the common problems that mooters might face during the competition, be it arbitration or court setting mooting? Maybe first time perks. So I think this question is very much suitable for Brother Aiman Farique. I'm sorry, but we cannot hear you. Ah,
Hello?
yeah,
Hello?
now we can hear
Okay.
you. All right,
Okay.
thank you.
Okay, sorry about that. Hello again. Sorry about that. The question was, what are the common problems that mooters might face during the competition? Okay. I guess the biggest problem that any mooter might face, regardless of your experience level, would be stress. Mainly because there is an expectation of you to do very well, even if it's your first competition. Mooting is always a competitive scene, even with your own friends and with your own teammates. But it's important for you to have a balance between your studies, the competition, and your social life as well. You have to be able to relieve that stress somehow, and regardless of how you do it, either going out with friends or something along those lines, it's incredibly important that you continue to do so even when you have the competition at hand. Of course, sometimes you may need to sacrifice that for time crunches and trainings, but it's still important for you to not break down during the competition. It has happened before. It is something of a worry for a lot of mooters. Another perhaps problem that people might have, especially for their first competition, is how do you conduct research? It's something that if you don't have a good coach, you may not necessarily even know. But thankfully, considering that we've started to have the Moot Club and the Moot and CC Club now, we have people who are experienced in mooting that are lending their times to coach as well, and not just lecturers, for example. And I'm not saying this to say that lecturers aren't able to be very good coaches, but obviously lecturers have incredibly tight schedules and they may not be able to help out on some matters. So yeah, if you have any problems necessary, most of these issues will be dealt with um, either by yourself or by, normally speaking, by a coach that is given to you during your competition. First timer perks. Well, I mean, depending on the competition you join, judges may not necessarily better on you as much if you're a first time mooter, but you don't expect that. You always expect for the judges to have incredibly difficult questions for you. There's not really much first time perks in the first place. Thank you.
All right, thank you, Brother Aiman. So for next question, I think for Sister Maryam, what does it mean by the disputes were kept confidential? And secondly, what is your advice for aspiring law students who want to join mooting but never have experiences in debates, competitions, or other oratory tournaments?
Thank you, Sister Naila, for the question, for the participant who asked this question. So there are two things here. Firstly, what does it mean by disputes are kept confidential? Secondly, you need to have an experience before you join mooting. Okay, so first of all, like I mentioned before, in arbitration, there are several aspects which are different from court litigation. So one of it is the dispute will be kept confidential. So what does it mean by that? Is that the whole dispute will be a private session. So it will not be an open court process. It will be in a closed room where only the relevant parties will be there and the arbitrators. And the decision of the dispute will not be published in any law journal. So you will ask yourself now, how do we find precedents if there are no case laws, no journals for arbitration awards? But the reason to this is because there is no precedent in arbitration. So you can quote any court cases or any scholarly writing, which is credible, of course, and they will be regarded as persuasive because nothing is binding on the arbitral tribunal. So that is what is meant by the disputes are kept confidential. Okay, and the second question is that, do you need to have experience before you join mooting? So the answer to this is no, you don't necessarily need any experiences. because the fact that you are already in a law school, you probably have a basic understanding of law. And this can be further enhanced when you join Mooting. And also, if you worry about your oratory skills, this will also be polished or enhanced when you do your trainings later. So you should not worry if you've never joined any debating or other public speaking competitions, because that will not be a hindrance for you to excel in Mooting. So that I hope that answers your question. That is all from me. Thank you.
All right. Thank you, Sister Maryam. So for the next question would be for Sister Hashima. So for Sister Hashima, what is the key in giving good consultations to your clients? Do you have to some sort of be empathetic to understand them better, or you should put emotions aside?
Well, what is the key in giving good consultations to your client? Do you have some sort of empathy to understand? Right. Okay. So when it comes to client consultation, right? Like the legal part of the legal field actually goes hand in hand with the psychological field, because at the end of the day, like I've mentioned before, like lawyers deal with people. So when client comes to you, to your office, or when a client comes to you during the competition, they come to you with a lot of legal problems, and with legal problems it comes it comes hand in hand with a lot of emotions. So you in client consultation, you cannot actually disregard their emotions totally. So how to have a good consultation session with your client is to acknowledge their emotion first. Acknowledge that, okay, you are feeling agitated right now, you are worried right now. And once you acknowledge, then you can control. So once you control your client, they control their emotion, you then will actually gain their trust. So they will trust you that you can actually handle your problem. So only when they trust you can you actually proceed with having a smooth sailing advising session, questioning or probing session. So always remember that first we have to acknowledge your emotion, and after we've acknowledged it, we've got to control our client. Then only we can actually proceed with the legal part that is giving them what is then the best choice, the best option for us to help them. So yeah, I hope it answers the question.
All right. Thank you, Sister Hashima. So for the next question is for Brother Muhannad Munir. In participating in either arbitration or court setting mooting, would it require a significant level of oral skills to be able to perform as a good mooter?
All right. Thank you for your question, Sister Naila. So my answer would be yes, it would require such skills. However, this is something I believe every student can work on, and it's not something where anyone is born with. So what is important is to just work hard and focus on how to improve your oral skills, so you can achieve a greater oral skills. So how would you do that? So firstly, as a general rule of thumb, always appear confident. And this can be done through various ways, such as, for example, maintaining eye contact, speaking in a firm tone, maintaining body language, and actually knowing your law. When I say actually knowing your law, I mean by know the basic requirements of what the law wants from you. What elements does it require, and how to prove them? Secondly, always be simple, and this can be done by having a structure and a roadmap so it's easier for judges to follow, and by using simple words and sentences. Lastly, if you want to improve your oral skills, learn from others. Watch your senior mooters if you're part of a mooting team. This is what I did because in my first year, I had a few seniors which I learned a lot from. Or even if you're not part of a mooting team, you can always watch mooters on YouTube and learn how they moot and their style and the way they say certain things, and emulating them would be very helpful in improving your oral skills. So that's all from me, and I hope it answers the question.
All right. Thank you, Brother Muhannad. So for the very last question for today, it is a question for Brother Rauf. For a first timer, do I get to choose which part of mooting I want to participate? For example, is it necessary to have experiences in common moots competition like arbitration, client consultation, or you can just jump straight into IHL roleplay?
Okay, thank you, Sis Naila, for the question. So, is it necessary to have experiences like arbitration and client consultation, or you can just jump straight to international humanitarian law role play competition? No, it is not necessary to have experience because, in fact, during my time of participation, I had no experience in arbitration, mooting, or client consultation before I joined IHL Roleplay. That was my first time representing IIUM to a national round competition, although I had an experience in internal moot competition, but that is on the internal level. So it was different with national level round. And you don't have to be worried because it all boils down back to your negotiation skills, your ability to think quick. You have to be quick-witted. You have to be adaptive with the situation. For example, let me share you a story. So during my time of participation, there was this one checkpoint. It was a lockup or a jail. So we would have to gather information from the detainees. So when we try to ask the detainee, they answered our questions, but we do not understand what language was that. So you would have to be quick-witted. You would have to look around you and think, what do I have to do to gather information from this person? So you see that there is the officer in there. So you might want to ask him for help to translate what you are asking and what were they answering to you. So that is what we did. And you can also use anything. It's based on your creativity. You can also use simple sign language, asking whether he or she had eaten or not, whether he or she received medical assistance or not. So at the end of the day, our coaches always remind us to be human, to embody the spirit of international humanitarian law, to protect the civilians, to protect the injured and the wounded. You don't have to worry because a month before the competition, usually they would conduct a workshop whereby they would conduct mock simulations of the real competition. So from there, you would know how to do it, and through practices and through trainings with the coaches, they will teach you more and more. So if you want to know more about international humanitarian law roleplay competition, you may go to our Moots Facebook page to see the interview with the past participant of IHL Roleplay competition that won the 2018 round, and they went to Aubagne, France, and represented Malaysia there. Okay, I think that's all from me. Thank you.
All right. Thank you, Brother Rauf, for the answer. So I believe that we already reached the actual last part or the end of our program. So I think for the last part, I just want to thank all the speakers for spending your time and your efforts in joining us, the Law Student Society, and other students of IIUM Center for Foundation Studies. And other than that, I just want to thank all the viewers that participate in our program today, which is Lex Moot. So inshallah, we will end our session today with Tasbih Kifara and Surah Al-As.